Welcome back to the Friday 5 for September 27th, 2024. My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota, and New York City. On Fridays, we like to take a quick look at 5 questions from the week and answer them in about 5 minutes. So let's get started. Question 1 this week. Can I send a demand letter if someone owes my business money? And in this case, what happened is the business works with customers and they're owed about $3,000 for a job they did. Now, the challenge when you work with an attorney is a debt from about $3,000 to $20,000 can often be eaten up by attorney's fees if you had to bring a lawsuit and make court appearances, and especially if there ended up being a trial over the amount that's due. If you're owed a smaller amount, it doesn't always make economic sense to bring in an attorney. So in this case, what the caller was questioning is, can they send a demand letter, or does it make more sense to have an attorney send a demand letter? And I have to admit that when I started practicing law, when you received a letter from an attorney, that was more intimidating and people were more likely to respond and negotiate and work out a debt. Unfortunately, here in 2024, a lot of times when we send lawyer letters, the person who owes you money either just ignores it or doesn't even want to deal with it, or will write back and say, forget you, I'm not going to even bother paying the money. So does it make sense to still send the demand letter? Yes, because then you can show a court that you tried to work out the debt before you had to file a lawsuit. Whether it comes from an attorney or not, the attorney's letter may be a little more persuasive to get the person to pay you the money, but in reality these days, a lot of people just ignore the mail, and you're going to end up having to decide whether to bring a lawsuit or not. Question 2 this week, what happens if I don't respond to a summary judgment motion? This is a pretty concerning call I got from a prospective client who is in the middle of a lawsuit, and the other party had made a summary judgment motion, and under the summary judgment motion, they were seeking to have both of the defendants win the motion and be dismissed from the case. So it really would be a case-ending motion if it was granted. And the concern here was that the caller's attorney, even though he'd received the motion, it had been filed back in August, hadn't put in any papers. And by the time the client called my office, that time to actually respond to the summary judgment motion had already elapsed. So even if you filed papers, they could be considered late, and the court may not consider them. And so a summary judgment motion, as we've talked about in some of my longer videos, is an important motion because it can end the case. So if the court orders summary judgment for the defendant in this case based on these motion papers, that would be the end of the case, and the plaintiff would not be able to recover any money and proceed in the case. So if you've been served with a summary judgment motion, make sure you know when your reply papers are due, and make sure you get those reply papers in, or you get more time from the court to respond. This is not the type of motion that you want to ignore. Question 3 this week, can an arbitrator issue a judgment? So in this case, we're working with a client on an arbitration, and there's a significant amount of money due. However, the opposing party actually hasn't responded. And we've been concerned because we have our first meeting with the arbitrator coming up, and we're not sure how the arbitrator is going to handle the case when one of the parties doesn't actually participate in the arbitration. It's interesting in this case as well because the other party is the one who drafted the contract, and under the contract, they were the ones who demanded that arbitration be the way to settle disputes. Until the question from the client is, why are we even doing arbitration? Can I get a judgment? And the short answer is yes, you can. In this case, what we do is we look at the contract clause and see what it says. And that contract clause said that both parties are going to waive the right to go to court and instead go to binding arbitration. And so that arbitrator can issue a final judgment for us. Question 4 this week, how do I know what to do if I'm the trustee of a trust? And this is a common question we get when people have been appointed trustee by somebody in their family or somebody else. In this case, it was actually on a special needs trust. And as we do in law, one of the first things we will always recommend is let's look at the documents. So if you've been appointed as a trustee under a trust, the first place to start is look at the trust document and see what it says. There'll usually be a provision for responsibilities of the trustee and then also some powers of the trustee. So in this case, we were looking for a power for the trustee to actually hire an attorney to help him act as trustee. And many trusts will have that. You can bring in attorneys, accountants, financial advisors. They want the trustee to have access to professionals, but not have the trustee have to pay out of their own pocket when it comes time to hire these professionals. So if you want to know what to do as the trustee of a trust, start with the document itself and see what it says and what your responsibilities are. Question 5 this week, another common one, can we add grandchildren to our will? So in this case, the parties had actually written their wills about 20 years ago. They have 3 kids now. They're all grown, and actually they have a bunch of grandkids. And what they wanted to do was add the grandkids to the will. And so, of course, the simple answer is yes, you can add grandkids to your will. It's just a matter of what you want their inheritance to look like. In this case, we're creating trust for the grandkids for educational purposes. So money can be used for private school, money can be used for college, money can be used for graduate school. So you can absolutely add your grandchildren to the will, and even if their parents are still alive. So in this case, we have 3 children. We have about 7 or 8 grandchildren. And so what they're looking to do with their will is actually give some money to their children, but also set aside separate money for the grandchildren. A lot of times the way your will be set up is that your 3 children in this case would inherit directly, but if one of them had passed away before you, then your grandchildren of that child would inherit. But in this case, the prospective clients don't want to do it that way. They actually want to set aside separate money for any grandchildren in addition to the money they leave for their children. So that's our 5 questions for the week. If you like this video, you can hit the like or thumbs up button below. You can head over to YouTube to subscribe for future episodes. I'll put a link below to submit questions for future episodes of the Friday 5. And you can always go to my website, 𝙃𝙀𝙍𝙀𝙊 to set up a legal strategy session or to ask more questions. We made it to the end of September. It's the 27th. I hope you have a wonderful weekend wherever you are and getting ready for October to arrive next week.